legal expert, Marius Du Toit, who has also been watching that case and joins me now. Marius, I suppose let me start with a broad question to you. What has stood out for you from the morning until now?
Well, I think what stands out to me is the fact that we are wasting court time in that this trial could commence. If that's something I could point out, I think if we have to be honest, the arguments that are being forwarded all pertains to a pre-trial procedure, if I can even call it that, because we are dealing with a special plea that was entered by the state, and we have the court having to adjudicate this based on the evidence or the documentation which has been provided. So it makes for interesting listening. I think from a listener's perspective, I think we have to separate this from the actual trial if we can, even though it's part and parcel of the same process. But I think we can separate from the main thrust of the evidence that will be adduced against Mr. Zuma and Thales. But I think it's interesting to listen to the fact that the legal representatives of Mr. Zuma are trying their level best to have the medical records, of course, not considered by the court. And secondly, of course, to have, as a whole, the prosecution disqualified from proceeding. And that's interesting because it's quite a novel process. It's something that I've never seen in court. But I suggest that wherever we have Mr. Zuma, it would seem that we have novel arguments, this is no exception.
In fact, Marius, let me ask you to go there directly, because I think for me that's been the top story of today, in that all along we thought we were dealing with a Section 1061H application where we thought it was about the argument that Billy Downer has no title to prosecute. He should be removed from this case, and any other prosecutor perhaps could be brought in. But today, Dalim Mpofu telling us, no, that's not what we're here for. We are here to say he has no title to prosecute. No one does in the NPA, not Mr. Downer, not Mr. Trengove, not Mr. Breitenbach. In fact, no one has, nobody in that institution, there's nobody in that institution who can give, let alone receive untainted title to prosecute. How extraordinary is that? Have you ever seen anything like that?
No, I've never seen that. I think we only have to go so far as to look at the Constitution to understand that the NPA is vested with the authority to prosecute people who commit offences. And to say that the NPA is disqualified would mean that we would have to ignore legal precedent when Mr. Zuma explored these issues in the ambit of bringing applications to the High Court. And we know the courts have said, well, listen, this matter should proceed. There's no basis for this matter not to proceed. So to now sneak this in under Section 106 and to say, well, not only does it affect Mr. Downer's title, but it also affects the NPA's title as a whole, is a bit risky, to be honest with you. I can't see that getting much traction in any court, having regard to the fact that these issues have been ventilated. You know, we're not hearing anything new other than, of course, the fact that the NPA is now as a whole put on trial. And if they can't proceed, then on what basis are we in court? So I can't see getting much traction and success on this argument put forward by them, Thulasizwe.
Let me take it very quickly then, Marius, to the arguments that they were now getting into just before we went to the break. The issues around the section, if we move from 106(1)(h) to 106(4) of the Criminal Procedure Act, where basically the circumstances under which once you've entered and perhaps been successful in one of the other pleas, the circumstances under which you are then entitled to an acquittal. Are you settled? Are you comfortable with the arguments that have been presented thus far as to why he is entitled to an acquittal?
So firstly, we must remember, Thulasizwe, that when any person pleads to a charge, he's entitled to a verdict. The moment you have pleaded, that's why many accused would like to have the plea done in a matter and then to postpone the evidence, because if the state's unable to proceed with the prosecution, the accused is entitled to a verdict by the court. So if you tender a special plea, which we essentially have here, and you have this matter before the court, then the accused is entitled to a verdict. And this verdict could be, well, very well, Mr. Mpofu, I agree with your arguments, and the accused is acquitted. Having said that, I don't think 106 is designed for what they're trying to achieve here. you know, essentially 106 deals with, and then this is the H, the subparagraph, deals with the title of the prosecutor. So if I can just pause to state for a moment, Thulasizwe, that this would typically be the case where the prosecutor was not properly sworn in, the prosecutor wasn't duly appointed by the NPA, or maybe it's a private prosecution and this person hasn't got the necessary locus standi to bring this matter before court, then you can attack the title of the prosecutor. But what they're essentially trying to do is they're trying to say, well, listen, you've got such dirty hands in this matter that you are compromised to such an extent, and that this matter has become an abuse of process. And that is quite far-fetched, to be honest with you. I can't see that getting much traction, but that's essentially what they're trying to do. But in any plea that's tendered by the accused in essence is entitled to a verdict, whether it's a guilty verdict or innocent verdict, but he's entitled to a verdict nonetheless. And essentially they're just repeating what the section says. But I just think the difficulty for the defense in this instance is the fact that they are attacking the title, but they're trying to give it a very broad stroke by saying, well, this is a constitutional issue, and as a result, the prosecution is doomed to failure because of the abuse of process. And when you look at that, Thulasizwe, you have to say to yourself, well, if the NPA can't prosecute, then who can prosecute? And that would disqualify everybody. But then you have to ignore the fact that these issues have been ventilated by the courts, have been considered by the courts, and it sounds like this is just an extra attempt or a so-called bite at the cherry to try and get this argument by Mr. Zuma in to say, well, listen, your hands are so tainted, I can't be getting a fair trial if this matter proceeds because you don't have a title to prosecute. And in that respect, I can't see that really succeeding.
All right, Marius Du Toit, thank you so much for your time and your insights here on eNCA. Hopefully we'll keep talking to you as and when this issue evolves. And towards the end there, Marius, sort of flag posting where we're going next, because that whole argument about whether or not there's anything new that we've heard that we've not heard previously in Mr. Zuma's other applications, including the application for a permanent stay of prosecution, which was unsuccessful, is exactly where we are headed next with the arguments that we started hearing from Thabani Mpofu. Well, he just really literally had just gotten up when the judge said, let's take a quick break. So expect him to be talking to issues of whether or not these are matters that have been heard before in one guise or another, that whole argument of res judicata or the issue of issue estoppel, which basically seeks to say you can't be allowed to come here and contradict findings of fact or findings of law that have already been determined by the courts at this point. That's where we are going next. And we'll take you back once the court resumes in Pietermaritzburg.